Good. Can you see my screen?
Yes, sir.
Okay, thank you. So today we will try to complete our first unit. The only point remaining is termination of agency that we will try to cover up today. So far we have discussed the agency, the relationship between the principal and the agent, as well as we have discussed the creation of agency, how the agency is created. That we have discussed so far. Now we will be discussing the last part of agency, and that is termination of agency. How a agency is terminated or how it can be terminated. That we will be discussing now. So termination of agency by act of the party to the contract of agency, by agreement between the principal and the agent. It is very simple to understand. It is mentioned very clearly in itself that by agreement between principal and agent. If principal and agent both are convinced that they do not want to carry out the business of agency, then by an agreement that they both are willing to end their relationship as principal and agent, or they want to cancel their uh, agency, if both are satisfied or if both want to do that, they can enter into an agreement and they can, with the help of that agreement, they can cancel the agency. Now next one is by revocation of agency by the principal. By revocation of agency by principal. Now revocation, we all know the meaning of revocation is cancellation. The principal can cancel the agency under the following terms. When principal may revoke agency, here we can say the principal can revoke the agent's agency if if the duties which were expected to be followed by the agent, if agent is not following those duties, if agent is not carrying out the business of agency as per the instructions of the principal, then the principal can revoke the agency of the agent. So very simple here. When an principal can cancel the agency, when the principal is satisfied that the agent is not working as per his instruction, because he has been appointed, the agent has been appointed by the principal to work on the instructions of the principal. If the principal comes to know that now the agent is not working as per my instruction, then the rule says, the law says, the agent has a right that the principal has the right that he can revoke the agency. Second one, compensation of for revocation of agent's authority by principal. Here we have to first understand why the agency has been revoked, why the agency has been cancelled. Now, compensation for revocation of agent's authority by principle. Here, we have to understand that when a principal is liable to pay compensation to the agent for revocation of his authority, and when he is not liable to pay compensation, to under which circumstances the principal, while revoking the authority of the agent, has to compensate the agent, and under which circumstances the principal is not bound to pay compensation to the agent for revocation or cancellation of his authority as an agent. So, when we had discussed the rights and responsibilities of agent, there we had very clearly discussed various rights and various duties given to the agent. If the agent is not satisfying those duties, then the principal is having a right that he can cancel the authority of the agent. And at that time, he is not bound to pay compensation to the agent. But if the agent is completing all the formalities or all the duties, he is following all the instructions of the principal, he is carrying out the business of the agency as per the instructions, as per the guidelines of the principal only, and still, if the principal wants to cancel his authority as an agent, at that moment, in those circumstances, the principal has to compensate the agent. So here we have to just understand that in which circumstances the agent will receive compensation from the principal for cancellation of his authority, and under which circumstances he is not going to receive any type of compensation for revocation of authority. Next one is reasonable notice of revocation to the agent by his principal. So, as per law, it is expected that reasonable notice means whatever period has been mentioned in the act or as per law. If the law says that at least 14 days notice should be given to the agent before cancellation of his authority, then it is compulsory on the part of principal that all of a sudden he cannot cancel the authority of his agent. He cannot just give a call to the agent or write a mail to the agent that from tomorrow onwards, I am canceling your authority as my agent. So that cannot be done. If the law says that a 14 days notice should be given, a 7-day notice should be given, or 21 days notice should be given, or a month notice should be given, that condition has to be followed before revocation of authority of the agent by the principal. Principal cannot cancel as per his wish. If the law says at least 7 to 14 days notice should be given, it has to be given before the cancellation of the authority of agent. If all of a sudden it is done, then as we have discussed in the earlier part or earlier point, that the principal then becomes liable to pay compensation, because it can be then termed as premature revocation. Now the next termination of agency is irrevocable agency. Now in the earlier slide, we have discussed that when the principal can revoke or cancel the agency of an agent. Here it is written irrevocable agency. That means opposite of that. Irrevocable means which cannot be cancelled. Earlier we had discussed that which can be cancelled. Now we will be talking about there are certain circumstances, there are certain things involved in the agency which makes the agency irrevocable, which cannot be cancelled by the principal. So under two circumstances, the principal the principal cannot cancel the agency. First one, where the agency is coupled with interest. Coupled with interest means where the agent and the principal, if they both are having interest in the agency, then it becomes irrevocable agency. That agency cannot be cancelled by the principal. Why? Because the agent has also invested in the agency. So till the agent is paid for that particular investment, that complete investment, the agency is irrevocable. It cannot be cancelled by the principal. Next one, where an agent has incurred personal liability. Personal liability means where the agent has incurred some personal liability. It means that where he has taken under his name some sort of guarantee in the form of, say, money or in other form also. The third party was not ready to sign the contract. So the agent made the third party believe that whatever information he is sharing is correct. And for that, he guaranteed or he took the guarantee that if anything happens otherwise, then he shall be held responsible for that particular contract. And he gives that guarantee in writing to the third party. On receiving that guarantee letter from the agent, the third party signs the contract with the principal. So here, till that guarantee period is over, the agency cannot be cancelled by the principal, because here again personal liability of the agent is involved. So if the agent has invested in the agency, or if there is some personal liability undertaken by the agent in the contract of agency, in the business of agency, till that is over, till the investment is returned or compensated by the principal, that particular agency is irrevocable agency. It cannot be revoked after with a reasonable notice of 14 days or a month also. It can be revoked only once the period of personal liability is over, or whatever investment the agent has made in the agency is returned with interest by the principal to the agent. Then only that agency becomes revocable agency, or the agency will remain irrevocable agency. Now, next one, termination of agency by renunciation of business by the agent. So, renunciation means leaving. Leaving is Leaving, not Living. So, leaving, when the agent leaves the agency, then we can say that it is termination of agency by renunciation of business by the agent. जो काम एजेंट कर रहा था प्रिंसिपल के अंडर, जब वो काम खुद से छोड़ देता है, उस काम पे जाता नहीं है, वहां पर जाके रिपोर्ट नहीं करता है, अपना जो जो भी उसका डे टू डे काम था वो छोड़ देता है, करता नहीं है, वहां पर नहीं पहुंचता है, तो दैट इज कॉल्ड एज renunciation of business by the agent. So first one, renunciation of agency by the agent, and renunciation of agency may be express or implied. How a agent can leave the agency or leave the business of the agency, here two options are available to him. Two ways are available. First way is by express way and by implied way. Now, express means he communicates either in oral form or in written form that henceforth he do not want to continue as an agent to the principal. So this is one way where the agent can leave the business of agency, and it is called as renunciation by express way. Or he can write a letter, or he can write a mail to the principal that henceforth from so and so date he do not want to continue with the business of agency, he wants to leave the agency. So this procedure will be called as the renunciation of agency by express way or express way. But the same thing we had discussed in the earlier slide, that how a principal can remove the agent, that he can remove the agent by giving him a reasonable notice. Same thing, but here how the agent can leave the agency. So agent can leave the agency by communicating either orally to the principal that he do not want to continue with the agency, and after 14 days he will not be there in the agency after 1 month, or he can that is also called as notice period. He can serve the notice period, and after the notice period or after completing the notice period, he will not be the agent, or he will cease to be the agent of the principal. That is one. And the other one is implied. Under implied, we all know the meaning of implied. Implied, the agent is not communicating either orally or in written form to the principal, but he is now ceased to be an agent by his conduct or act. He is not reporting to the office. He is not joining his duties as an agent for 1 day, for 2 days, for 15 days, for a month. That means by implied way, now he has renounced the business of his agency. तो वो बता के भी छोड़ सकता है, फोन करके छोड़ सकता है या मेल करके छोड़ सकता है, या फिर सीधा सीधा काम पर जाता ही नहीं है एजेंट प्रिंसिपल एजेंसी के, तो कुछ दिनों के बाद अपने आप समझ लिया जाएगा कि एजेंट ने वो एजेंसी छोड़ दिया है, प्रिंसिपल का अब वो एजेंट नहीं है। कॉम्पनसेशन फॉर रिनंसिएशन बाय एन एजेंट, so that we had discussed in the previous slide also, that when a principal is liable to pay compensation and when a principal is not liable to pay the compensation, same thing is applied here also. Compensation for renunciation, if the agent gives a proper notice before renouncing the business of agency, then we can say that yes, he is not liable to pay compensation to the principal. In the earlier part, we had seen that when an principal is liable to pay compensation for revocation the authority of agent, अचानक से अगर प्रिंसिपल ने एजेंट को निकाल दिया विदाउट प्रॉपर नोटिस, विदाउट अ वैलिड रीजन, then the principal is supposed to compensate the agent। 1 साल के लिए एजेंट को रखा था, 6 महीने के बाद, 7 महीने के बाद, 8 महीने के बाद प्रिंसिपल को ऐसा लगा कि एजेंट की जरूरत नहीं है, उसने एजेंट को निकाल दिया। 1 साल के लिए रखा था, 8 महीने में निकाल दिया, मतलब 4 महीने पहले। नाउ दिस टाइप ऑफ रिवोकेशन इज कॉल्ड एज प्रीमैच्योर रिवोकेशन। Without a valid reason, if premature revocation is done, then in those circumstances the principal is bound to compensate the agent। कोई मिसकंडक्ट नहीं था, कोई इनसबॉर्डिनेशन नहीं था, कुछ नहीं था, फिर भी निकाल दिया तो प्रिंसिपल को कॉम्पनसेट करना पड़ेगा। नाउ सेम प्रिंसिपल और सेम सर्कमस्टांसेस आर देयर इफ सपोज now if all of a sudden 1 year is the contract between the principal and the agent has accepted in the contract that yes, I will work as an agent for a period of 1 year, and there is a contract between the principal and the agent. After 8 months, the agent, without any valid reason, stops coming to the work of agency. So it will again be called as premature revocation or premature renunciation। जो एजेंट को बिजनेस छोड़ना है, एजेंट को अपनी अथॉरिटी अगर छोड़नी है, अपना जो जो भी कॉन्ट्रैक्ट है वो छोड़ना है, तो कब छोड़ सकता है वो? 1 साल पूरा होने के बाद लीगली ही कैन लीव द कॉन्ट्रैक्ट ऑफ एजेंसी, but without any proper reason, valid reason, if he is renouncing, leaving the business of agency, that will be termed as premature revocation, and here the agent is liable to pay compensation to the principal। जैसे वहां पे प्रिंसिपल ने अगर पहले निकाल दिया तो प्रिंसिपल को कॉम्पेंसेट करना पड़ेगा एजेंट को। अब एजेंट ने अगर प्रिंसिपल का काम बिना किसी वैलिड रीजन के पहले ही छोड़ दिया कॉन्ट्रैक्ट से, तो यहां पर एजेंट को प्रिंसिपल को कॉम्पेंसेट करना पड़ेगा, एंड दैट इज कॉल्ड एज compensation for renunciation of by an agent। And under which circumstances now the agent is not bound to pay compensation? If the agency period is over, after 1 year, if he leaves the agency, then automatically the period is over, the contract is over, so here the agent is not bound to pay compensation। Even if the agent is leaving the business of agency before the validity, that is before 1 year, but if he is able to give a valid reason, अगर valid reason दे पाया वो, तो पहले अगर छोड़ देता है बिजनेस तो भी उसे कॉम्पेंसेशन देने की जरूरत नहीं. Valid reason means the reason which can be accepted by the court. Now suppose the agent has met with an accident and now he is not physically fit to carry out his business of agency, and still 5 months are remaining for completion of contract of agency, and because of that medical condition he leaves the business of agency. Here the circumstances, or we can say the condition for, or the what we can say, that why he has left the agency. Now this condition definitely will be accepted by the court because of his medical condition. If the person is unable to carry out the business of the agency, here the principal cannot claim compensation from the agent. So valid reason should be given. If the reason is valid, if the reason is acceptable by the court, then court is not going to direct the agent to pay compensation even if the revocation was premature. 1 साल के लिए एजेंसी का कॉन्ट्रैक्ट था, 5 महीने के बाद ही एक्सीडेंट हो गया, 7 महीने का पीरियड बचा है. Medically it has been proved that now this particular person who is agent, he cannot work. अगर ऐसा हो गया तो कोई भी कोर्ट में ये एक्सेप्ट नहीं हो सकता. Compensation case filed by the principal will be rejected on the grounds that medically if the person is unfit, then it is 100% acceptable and it will not be termed as premature revocation. Now next, termination of agency by operation of law. Now completion of agency business. Very simple. The business for which the agency was created, once that business is over, automatically the agency gets over. Now the principal, suppose for example the principal was having 3 flats to be sold in an building, and for selling those flats he appointed an agent. He gave the responsibility to the agent for a particular commission, for a particular salary, that I'll be paying you this much of rupees if you can sell 3 flats for me. The agent accepted the offer and there was a contract between the principal and the agent for selling those 3 flats. Now once these 3 flats are sold, the object of the contract is that 3 flats to be sold. Now once these 3 flats are sold, automatically the contract between the principal and the agent is over. They need not carry out a separate contract to cancel the previous contract. कोई अलग से कॉन्ट्रैक्ट बनाने की जरूरत नहीं है कि जिसके लिए हमने कॉन्ट्रैक्ट बनाया था वो अब पूरा हो गया, इसीलिए हमारा पहले वाला कॉन्ट्रैक्ट खत्म हो गया. ऐसा करने की जरूरत नहीं है, and that is called as termination of agency by operation of law. Under that, it is covered under completion of agency business. So when 3 flats are sold, that means the business is over and there is no contract remaining to be performed between the principal and the agent. So the contract automatically is considered as complete or over. Next one, expiry of period of time. The contract between the principal and agent was created for a period of 6 months. Once the 6 month period is over, automatically the contract of agency between the agent and the principal is over. Simple. Next one, destruction of the subject matter. Destruction of the subject matter. Now we will continue with the first example. The contract between the principal and the agent was created for selling 3 flats. And the agent has to sell these 3 flats within a period of 2 months. 2 महीने दिए गए कॉन्ट्रैक्ट में, जो टर्म्स कंडीशन बने कि 1 लाख रुपया, 2 लाख रुपया इतना कमीशन मिलेगा, जितना भी फिक्स हुआ दोनों के बीच में, एजेंट और प्रिंसिपल के बीच में कि डील हुई. प्रिंसिपल इज रेडी टू गिव हैंडसम कमीशन to the agent if the agent is able to sell the flats within a period of 2 months. पर 2 महीने के अंदर अंदर ही उसे वो फ्लैट्स बेचने. That is the contract. Now we are talking about destruction of the subject matter. Subject matter क्या है यहाँ पर? मेन सब्जेक्ट क्या है? Selling of flats. Flat. अब 2 महीने से पहले जब वो फ्लैट बिक रहे थे, बेचने वाला था एजेंट, उससे पहले ही अर्थक्वेक हुआ, भूकंप आया और जिस बिल्डिंग में वो 3 फ्लैट थे वो बिल्डिंग ढह गई, गिर गई. अब ना बिल्डिंग बची ना फ्लैट बचे, मतलब डिस्ट्रक्शन ऑफ सब्जेक्ट मैटर. Automatically the agency is over. Now here the agent cannot claim the commission from the principal. Why? Because when there is no subject matter, there is no question of completion of the contract between the principal and the agency. So automatically the contract is said to be over. So there is no relationship between the principal and the agent. Why? Because there is destruction of the subject matter. Next one, insolvency of principal and in some cases that of agent. Insolvency of principal. So insolvency every one of us is aware of. जब कोर्ट द्वारा किसी को दिवालिया घोषित किया जाता है, बैंकरप्ट घोषित किया जाता है, so that is called as insolvency. Once the principal is declared insolvent, then there is termination of agency business between the principal and the agent. Death of the principal. So अगर प्रिंसिपल की डेथ हो गई तो ऑटोमेटिकली कॉन्ट्रैक्ट ऑफ एजेंसी खत्म हो जाता है. डेथ ऑफ एन एजेंट, अगर प्रिंसिपल की अगर एजेंट की डेथ हो गई तो भी कॉन्ट्रैक्ट खत्म हो जाता है. दैट इज वी आर टॉकिंग अबाउट टर्मिनेशन ऑफ एजेंसी बाय लॉ. ठीक है, एज बाय ऑपरेशन ऑफ लॉ. नेक्स्ट वन, इंसेनिटी ऑफ आइदर पार्टी. दोनों में से एक पार्टी, आइदर द प्रिंसिपल और द एजेंट, इफ they become, either party becomes insane, of unsound mind, then the contract of agency between these two parties is automatically terminated by operation of law, because the law says that the contract remains valid only if both the parties are of sound mind. All of a sudden, because of some problem, because of some accident, because of some sort of circumstances, if one of the party to the contract, either principal or an agent, loses their mental balance, becomes unsound mind, then the contract is terminated. Next one, principal becoming an alien enemy. We have already discussed the meaning of alien enemy. So the principal, suppose the principal is from the other country, and when the contract was signed between the principal and the agent, everything was fine between the two countries. But after some time, there was a war or war-like situation, then the principal becomes alien enemy. So when the principal becomes alien enemy, automatically the contract of agency is terminated. Next one, object of agency becoming illegal or unlawful. So earlier the object was lawful, later on the object became unlawful. So when, because of passing of some law, if the object becomes unlawful or illegal, the contract of agency is terminated on that ground. For example, sale of plastic carry bags is banned in the state of Maharashtra. For the last, I think 2 to 3 years back, there was a rule passed in the state of Maharashtra that the very thin type of carry bags are banned. So 3 years back, or before passing of that rule by the government, so any principal or agent who had signed the contract between them to carry out that business activity regarding manufacturing of that plastic carry bags or plastic sheets, which are banned now, and earlier it was valid. The agency was created for 1 year, but after 6 months, when the government started implementing this rule, then automatically this agency will be called as termination of agency. Gutka is banned in the state of Maharashtra. But earlier, when it was not banned, and when there was a deal, when there was a contract between the principal and the agent related to manufacturing of gutka or sale of gutka, it was valid. But the moment the act was passed that henceforth the sale or manufacturing of gutka is banned in the state of Maharashtra, their agreement, which was earlier considered as legal, now as the subject, as the object has become illegal, the entire contract will be called as terminate, will be considered as terminated, because it cannot be accepted in any court of law. 6 महीने बचे हैं कॉन्ट्रैक्ट के. अब प्रिंसिपल को ऐसा लगता है कि उसने बहुत सारा गुटखा एजेंट को दिया है, एजेंट वो बेच नहीं पाया, इस वजह से प्रिंसिपल का नुकसान हुआ. अब एजेंट क्यों नहीं बेच पाया? क्योंकि गवर्नमेंट ने बीच में ही रूल लेकर आ गए कि आज से आगे और कल से गुटखा स्टेट ऑफ महाराष्ट्र में बैन. अब प्रिंसिपल कोर्ट में जाता है, कोर्ट में केस फाइल करता है एजेंट के खिलाफ कि एजेंट को अपॉइंट किया था कमीशन बेस पे, हैवी कमीशन दिया था कि ये जितना भी गुटखा है जो गोडाउन में रखा है प्रिंसिपल के, वो सारा एजेंट ने प्रॉमिस किया था कि आई विल सेल दैट। उसी प्रॉमिस के तहत उसे एक हैंडसम कमीशन दिया गया है। यहां पर कोर्ट इज नॉट गोइंग टू एक्सेप्ट द एप्लीकेशन। व्हाई? बिकॉज अर्लियर द ऑब्जेक्ट वॉज लॉफुल, but now the object has become unlawful, illegal। जब इलीगल है तो एजेंट सेल ही नहीं कर सकता। एजेंट को पीरियड कितना दिया गया था? 12 महीने का। 6 महीने हुए हैं, 6 महीने बचे हैं, पर अब वो ऑब्जेक्ट ही इलीगल है, एजेंट सेल ही नहीं कर सकता है, तो यू कैन नॉट रिकवर दी डैमेजेस, यू कैन नॉट रिकवर दी कॉम्पनसेशन फ्रॉम दी एजेंट। This will be the decision of the court. Why? Because the object of the contract has become illegal. And the last one, incapacity of the principal or agent. Incapacity. So again, incapacity we have discussed in the essential elements of the contract. Under that, we had discussed capacity of parties. Anyone who can recall what is the meaning of capacity of parties? 4-5 points we had discussed under capacity of party, and same points are to be used here also. Anyone who could recall the capacity of parties? Am I audible to all?
Yes, sir.
Thank you. Yes. Anyone who could recall the concept of capacity of party? Same is to be implemented here also. Incapacity of principal or agent. Capacity of party. क्या है capacity of party? Yesterday there was a news article in the newspaper. I don't know how many of you have seen that article, and that article was related to the examination. That now I'm not sure about the authenticity of the article, because anything which is printed in newspaper or which comes through TV, we are not supposed to believe on that, because we can only believe on the written notification which is published by the university. Just a news article I'm just sharing. It is not at all, please note, it is not at all authentic news. It may be true, it may be wrong. In that article it was written that the government and the university is trying to decide upon the dates of first year examination. They had not mentioned any course, and they are trying to finalize the dates in the mid of February or at the end of February. They had not mentioned any type of courses, which type of, बस इतना मेंशन किया गया था कि फर्स्ट ईयर के एग्जाम्स। तो प्लीज नोट कि हलचल शुरू हो गई है फाइनल एग्जाम्स की तैयारी के लिए। इसका ये मतलब है कि बहुत जल्दी आपके फाइनल एग्जाम शुरू हो सकते हैं, शायद वो मार्च में हो जाए। जब तक रिटर्न नोटिफिकेशन नहीं आती तब तक हम लोग आपको नहीं बता सकते डेट कब है, क्या है। और न्यूज़पेपर पे कुछ भी आता है तो उसे ज्यादा सीरियसली लेने की जरूरत नहीं है। सिर्फ इतना ये ध्यान रखना है कि एग्जाम्स का प्रिपरेशन आपको शुरू जल्दी से जल्दी कर देना चाहिए, राइट? अदरवाइज it will be difficult if offline exams are conducted. For online exam, I need not tell you, because what happens in online examination we all are aware of. But what happens in offline examination, that we also know, and I hope that you can also recall. Okay. So capacity of parties. Please start studying whatever we are discussing in the sessions. Yes, capacity of party, there we had discussed. If no one is contributing that, then I'll be contribute. I'll contribute. Okay, capacity of party, there we had discussed certain points, and those points that we had discussed were that capacity of party means that the party should not be under the influence of drinks or drugs. Number one. Next, capacity of the party. Both the parties to the contract should be major. Next, capacity of the party. Both the parties to the contract should be of sound mind. So in that way, we had discussed certain 5-6 points under capacity of parties. So under incapacity of principal or agent, here when the agent loses the mental balance, or the principal loses the soundness of mind, automatically the agency is terminated. When it comes to know, or when it is proved that either the agent or the principal is not major, have not attained the age of majority, at that time, again, the contract is terminated, because under capacity of party, it is clearly mentioned that both the parties at the time of contract should be major. The contract can be terminated if either party is able to prove in the court of law that when the contract was signed, that party was under the influence of alcohol or drink. So that is known as incapacity of principal or agent. So these were some of the ways where the agency can be terminated. So that is the end of our first unit. If you have any query related to anything, please go ahead, or else we will. How much time is remaining now?
10 minutes.
10 minutes are there. So if you have not understood anything, please go ahead, or we will start with our next unit. That is, what is our next unit? Unit number 2.
Sales of Goods Act.
Very good. Sale of Goods Act. Yes, any query? Okay, very good. So no query. So now we had completed the Contract Act or it is also called as the Indian Contract Act 1872. 1872 means it is the year in which the act was enacted. As we were ruled by the Britishers were responsible for implementing this act. It doesn't mean that we are following the same act as it is. As the time changes, and depending upon the changes in the environment, business environment, often there are changes made in the existing contract through amendments, and those changes are called as amendments done in the act. So various amendments have been done in the Contract Act 1872. Now we will be starting with our second unit, and the second unit is related to sale of goods. And this act was passed in the year 1930. Again, as it is before independence, Britishers were responsible for the enactment of this act. Sale of goods. What does it mean? Sale of goods. Sale, we all know what is sale and goods. So sale, here sale means selling. Here sale is not, there are two types of sale. One, sale means SALE, and that sale is selling. The other sale, again, the spelling is same, SALE, but that sale we often find in the posters which are there in the when we go for shopping in malls. 40% sale, 30% sale, that is different. That is discount, we can say. That sale is for related to discount. And sale of goods, under sale of goods, the sale which we are going to discuss is selling of goods. Selling of goods. So we will just have an overview just for 5 minutes, and then we will end the session. And in the next session, we will start with the definition of sale of goods. So sale of goods. So selling of goods. Now, which type of goods we are going to discuss in this is movable goods. We are not going to discuss immovable goods. Now, there are two types of goods. One is called as movable goods, and the other one is called as immovable goods. Now, electronic items or electrical items or other items which can be moved from one place to another, these are categorized as movable goods. So sale of those movable goods we will be discussing. There are certain goods which are immovable. Now suppose flat, house, these are immovable goods. ये ऐसे गुड्स हैं जिनको हम एक जगह से दूसरी जगह नहीं लेके जा सकते. So these goods are not included in the Sale of Goods Act. Immovable goods के लिए अलग act है, and that is called as transfer of property. So that transfer of property, as it is not included in our curriculum, in our syllabus, so we are not going to discuss that. We will concentrate only on movable goods. Now, this goods which are to be sold, how these are to be sold, that we are going to discuss in this unit. We are going to discuss various types of goods. what are the various types of goods? There are various types of goods. Under that, three major types of goods are there. We are going to discuss. First one is called as ascertained goods. Second one is unascertained goods. And the third one is specific goods. The meaning of these goods we will be discussing in our coming sessions. Next thing which we will be discussing in the contract sale of goods act, how the goods are to be sold. So there we will be discussing that how the goods can be sold, what are or how many parties are involved in the selling of goods or sale of goods. So there are two major parties involved in the sale of goods. One is called as seller and the other one is called as buyer. Seller is the person who sells the goods and buyer is the person who buys that good. तो एक खरीदार है और एक बेचने वाला है. जो गुड्स को बेच रहा है दैट पर्सन इज कॉल्ड एज सेलर. जो वो गुड्स को खरीद रहा है दैट पर्सन इज कॉल्ड एज बायर. There are certain rights given to the buyer and there are certain rights given to the seller. That also we are going to discuss. Now some part we will be discussing in sale of goods, and as we have discussed that as and when the business environment changes, there are certain changes made in the existing acts also. And for sale of goods, a complete separate act has been enacted by the government that we are going to discuss in our fifth unit, and that is called as Consumer Protection Act. So Consumer Protection Act is, we can say that it is not entirely a new act, but it can be called as the extension of Sale of Goods Act. In Consumer Protection Act also, we are going to discuss what are the rights of consumer and what are the rights of the seller. There also two parties are involved. Here also two parties are involved. But here in sale of goods, both the parties enjoy equal weightage. दोनों का जो वेटेज दिया गया है दोनों को, that is same 50-50. But when we will be discussing Consumer Protection Act, as the name itself says, consumer protection, that means protection of buyer. It indicates that it is not giving clear or 50-50 weightage, more weightage to the consumer or most weightage to the consumer and least weightage to the seller. That is done in Consumer Protection Act 1986. But here both the seller and the buyer are given equal rights and responsibilities that we are going to discuss in the coming sessions. So we will end the session today here. Thank you everyone for joining today's session. Tomorrow we will continue with the, tomorrow or maybe on Monday, whenever we will be having a session, we will continue with the Sale of Goods Act. Thank you everyone.
Thank you, sir.
Thank you.